Good day. We are the Group 5 and we are here to present to you the case of EGV Realty Development Corporation versus Court of Appeals dated in July 20, 1999. The General Register number of this case is 120236. The petitioner for this case is EGV Realty Development Corporation and the respondents are Court of Appeals and Unisphere International Incorporated. Here are the facts of the EGV Realty Development Corporation versus Court of Appeals case. The petitioner EGV Realty Development Corporation is the owner of a 7-story condominium building known as Christina Condominium. Christina Condominium Corporation, or CCC, holds title to all common areas of Christina Condominium and is in charge of managing, maintaining, and administering the condominium's common areas and providing for the building's security. Respondent Unisphere International Incorporated, or Unisphere, is the occupant of Unit 301 of the said condominium. On November 28, 1981, Unisphere's Unit 301 was allegedly robbed of various items worth 6,165 pesos, and the incident was immediately reported to CCC. The same thing happened on July 25, 1982, where the items carted away were valued at 6,130 pesos, bringing the total value of items lost to 12,295 pesos.
On October 5, 1982, Unisphere demanded compensation and reimbursement from CCC for the losses incurred as a result of the robbery, but CCC denied any liability for the losses demanded by Unisphere, stating that the goods lost belonged to Amtrade, a third party. As a consequence of the denial, Unisphere withheld payment of its monthly dues starting November 1982. On September 13, 1983, Unisphere received a letter from CCC regarding the payment for the past dues. On December 5, 1984, EGV Realty executed a deed of absolute sale over Unit 301 in favor of respondent Unisphere. Thereafter, Condominium Certificate of Title Number 7010 was issued in respondent Unisphere name, bearing the annotation of a lien in favor of petitioner EGV Realty for the unpaid condominium dues in the amount of 13,142.67 peso. On January 28, 1987, petitioners EGV Realty and CCC jointly filed a petition with the Securities and Exchange Commission, or SEC, for the collection of the unpaid monthly dues in the amount of 13,142.67 peso against respondent Unisphere.
The issue for the case is whether or not setup or compensation has taken place in the instant case. So the Court of Appeals dissertation on the matter is commendably instructive, but unfortunately, it reached a different conclusion. Unisphere is indebted to the corporation for its unpaid monthly dues amounting to 13,142 pesos and 67 cents, and stopped paying their monthly dues to the corporation on September 23, 1983 without notifying the latter. It was only on February 24, 1984, or 5 months after, that it informed the corporation of its suspension of payment of the condominium dues to offset the losses it suffered because of the robberies. The argument of CCC, or the Christina Condominium Corporation, is that there was no agreement happened between the unit owners in the light of incurred losses happened. Hence, the reimbursement of the value of the items lost because of the robbery should be against the security agency and not with the corporation.
According to the Article 1278 of the New Civil Code of the Philippines, compensation or offset takes place when two persons or entities in their own rights are creditor and debtor of each other. It is important to make a distinction between a debt and a mere argument. A debt is a sum that has already been calculated. It is an argument that has been formally passed down by the court or quasi-judicial bodies to which it may be applied and considered a debt in a law. On the other hand, an argument is the debt of an embryo. It is a merely proof of a debt and must be passed before it evolves into what is properly called a debt by the mechanism required by the law. However, in the absence of any such categorical admittance by an obligor or final decision, no compensation can take place.
Until it is acknowledged by the debtor himself, the inference that he is indebted to another cannot be simply and pronounced. No matter how persuaded he may be of the truth of that inference, the indebtedness must be one that is acknowledged by the accused debtor or pronounced by the final judgment of the competent court, or in the present case by the Commission. Although the respondent Unisphere does not reject its liability for its outstanding debts to the petitioner, the latter does not take any responsibility for the consequences suffered by the former occasion as a result of the burglary. Regardless, what the Unisphere respondent has against the complainant is a claim, not a debt. Checked by the aforementioned benchmark, it has been properly identified that the set-off or compensation is reasonable here, since there is no proof to prove that the applicant EGV, Realty, and CCC and the respondent Unisphere are each other's debtors and creditors.